Okay. There's been a lot of confusion. Temple Moors versus land moors. What I mean by land moors is that we can prove that the land is ours. Temple Moors cannot. They utilize Chapter 47, and they speak about the vast estate of the mentioned Prophet Noble Drew Ali, but yet they know nothing about the family bloodline or ties in which that correlates to the heirs of Henry Turner versus the United States and other cases. So they come up with this nonsense saying, well, that case was thrown where? Where was it overthrown at? Eminent domain? See, these are questions in which that we have to talk about. Chief Zephaniah.
Peace, Chief.
Okay.
Yeah, I'm here.
Well, I see that you commented to Brother Roger Brewington.
Right. Yes, sir.
Now, that's why I asked him the question. So she made up the cases? She made up the heirs versus Henry Turner? The heirs of Henry Turner versus the United States? She made that up? Or was that an actual case?
Yeah, Chief, you could tell that's somebody who's just regurgitating rhetoric. Like, anytime someone could say that she made something up, but like you said, the court case, she can't make up her entire court case. She can't make up what they're saying about her in the United Nations. This isn't made up. This is facts that have been stated by others. So yeah, he was confused, like you said.
Yeah, by those who never been to the United Nations. I've been to the United Nations since 2007, off and on, 2007. And I can tell you for a fact that they recognize us. There's no issue. We have put our documents into the treaties, the various treaties, and it holds true. The United Nations does not just let anyone into the facility. You have to have tribal national ties. Temple members will not get in. Simple. Elahu Pleasant Bay tried getting in, doing his thing, could not get in. Temple Moors tried getting in, doing their thing, could not get in. I was there. I seen it happen.
Fahim Tecumseh El-Bey, Washington East.
So I was there, looking at these things as they took place. So people who following the Moorish or Moroccan government / under Swift Angel Elahu Pleasant Bay, that's fine. However, at the time, he could not get into the United Nations. And like I said, neither could the Moorish Science Temple of America with their little flimsy paper card. The United Nations will not take that. So, allegedly, she made up information, but I'm trying to figure out how she made up a bloodline, how she made up grants, land grants in particular. How did she make up court cases surrounding the land grants? can't make that up. But this is coming from more than just one source. So we're going to go over today, what is a land grant? So someone can read for me.
I got you, Chief. Land patents and grants as trust. This is a completely separate venue than at law. It requires a court of equity and chancery to enforce it if needed. Your paperwork sets the jurisdiction. Disclaimer: I'm not an attorney. This is not legal advice. This is a very simplistic overview of the formation and expression of a trust. You will need to do your own research and paperwork. Trust. First, in the previous PPC, did you notice that there is a trust expressed in the patent grant as well as in the Constitution for the United States of America and the several union states that make up the United States of America? The element of a trust are intent, purpose, parties, specific res, and a method of formation.
So the land grant in which that the Empress is tied to, which is called the Spanish and French land grants, those are supreme law of the land. If you go to Article 6 of the Constitution, someone read Article 6 of the Constitution for me. Article 6 of the Constitution.
If nobody will read it, I'll go look it up. But if somebody want to get that.
Okay. Anyone? Go ahead, Chief Zephaniah. You can read it then.
Yeah, I'm looking it up right now for you, Chief. 1 second.
Okay.
I have it. Article 6 of the Constitution of the United States. All debts, contracted, and engagements entered into before the adoption of the Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or law of any state to the contrary notwithstanding. The senators and representatives before mentioned, and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office or public trust on the United States. That was Article 6.
Okay. Public trust. All right, so we're looking at treaties. We're looking at trusts. We're looking at supreme law of the land. We're looking at information on which that was designed before the Constitution for the United States of America. The treaties in which that the Empress speaks of, which is the Spanish and French land grants, were before the signing of the Constitution. And because of that, what does it say in the first 3 sentences, Goddess?
The first 3 sentences: all debts contracted and engagements entered into before the adoption of the Constitution shall be as valid. So it's supposed to be valid.
Right, it's supposed to be valid. So when did it get overturned? When do land grants get overturned? Somebody explain that shit to me.
In other words, they don't get overturned.
Right. They can't get overturned. According to their own Constitution. They can hide the information. They do that very well. At least they did. But as we just seen, land grants are trusts. Land grants are trusts. Land grants prior to the establishment of the Constitution for the United States of America are valid because these Spanish land grants was formed before the United States formation. So that's number one. Land grants can't be overturned. Continue on.
Good question, Chief.
Yes.
So where it says specific res being like a actual property being transferred into a trust, that res being that land.
Right.
Okay, just wanted to make that clear. Most definitely.
Yes. And the land is what is called the Louisiana Purchase, which was never purchased, number one. It was never called Louisiana, which is allegedly named after King Louis, which is fine. However, it was always called the Washita proper. All right, continue on.
I say ownership versus stewardship. All claims of ownership must be first acknowledged as foremost and originally granted by God, who grants good gifts, anything that transfers to his children. We are heirs/heirs and assigns.
So that's the reason why it can't be overturned, is because it's straight from God.
His gifts are for the most part a stewardship to hold, possess, use, enjoy, protect, nurture, dress, and harvest the bounty for the benefit of the beneficiary, for our use and enjoyment, and to generate an attitude of gratitude back to God as the giver of gifts.
All right, so we are the beneficiaries, we are the heirs, heiresses, and assigns. That's our status as nationals of Washita. Simple. Simple. Continue.
Huge. What we do with what has been granted is our gift back to God, as it is a means of blessings others with what was given. Some of this may be a tithe, some may be an offering, either to the church or used to directly bless those in need. Keep this initial acknowledgement in mind as foundational understanding throughout the rest of this presentation. Specific res. Inequity, whatever can be implied, can be expressed. If you have a contract, a will, an agreement, method of formation, this can be implied trust. This can be an implied trust that parties will perform a requested or required duty, purpose for a specific intent that you're expressing as a trust. And if it's a more formal trust, you have tendered lawful coin as valuable consideration, which conveys title. The title to the land can be trust res, being held in trust by another for the benefit of the beneficiary.
And guess what? The so-called $15 million in gold, in which that's supposed to have been from Thomas Jefferson to Napoleon, number one, was never fully serviced. Over $3,750,000 in gold sunk beneath the ocean floor in Florida. So full renderance of payment was never received. And the only thing in which that Napoleon allowed for them to purchase, because you could not sell the Louisiana Purchase / Washita proper, was some barracks and streets in New Orleans. That's it. That's it. So they have us under the illusion that all of the so-called 13 some odd states, all the way up into almost the whole of Canada, was purchased as part of that Louisiana Purchase from Napoleon. And that is a lie. And this is where history goes wrong at, because this is where the Europeans put in their nonsense in order to steal our land. Which obviously we can prove, because there's 68,883 acres of land in which that even Louisiana stated, which I have the notes, the letters to the Empress, in which that they specifically said the land does not belong to them. But then who the hell does it belong to? It doesn't belong to the government. It doesn't belong to Louisiana government. So it's not federal. It's not state. Then who the hell does it belong to?
Belong to us.
Bingo. Exactly. That's the only answer. And this is what the Empress found out over her 40 years of research. And Negroes in the temple rather debate the subject instead of joining and acquiring the vast estate. Debate about what? Religion? Prophet Noble Drali? Islam? What? I mean, what? What is there to debate? You have land, nigga, in which that you need to acquire.
There's nothing to debate. There's no debate.
Right. I mean, what subject, right? What subjects do you want to debate? That's what gets me. Oh, she made it up. How? Everything falls into place. The land grants, the court cases, the letters from Louisiana, everything that she did falls into place. How did she make up anything? Oh, was she not the mayor of 2 cities? Monroe, Louisiana, and Richwood, Louisiana? She was the mayor of both cities. What the fuck did she make up? Oh, Return of the Ancient Ones? She showed you the land grants in there. The United States versus the heirs of Henry Turner. What did she make up?
She didn't make up anything.
That's what I'm
They
trying
won that case.
That's what I'm trying to figure out.
Didn't make up nothing.
He was saying she made something up, but you can't really point out specifically what she made up.
They making something up. That she made something up. That's the issue. And she didn't make up anything.
That's what they're trying to hide.
Right. That's the silliness of all of this.
Looking at patents and grants as trusts. So, in a land patent or grant, we have the following: intent to dispose of public land into private hands, purpose to cede, relinquish, quitclaim, and sever all right and title in the land to previously possessed by government and issue letters patent of grant for the same interest, right, and immunity. The government had possessed a loyal title to private men, women, or entities such as a railroad. The parties are identified. The res is the title to the private land granted and granted any stipulations and valuable consideration, lawful coin in hand given as valuable consideration to transfer title to equitable right and possession. Trust indentures. This is sometimes called the law of the trust. Trust indenture stipulates how the trust will be operated and regulated. If a land patent grant has any exceptions or reservations as to what was granted, this is part of what is regulated in the trust indenture. In Texas, the original land patent grants were protected when Texas became one of the several unions of the several states to remain in the exact state under the state of Texas, as under the preceding government known as the Republic of Texas. Trust indenture continued. When Texas was about to be annexed into the several union states known as the United States of America, the men forming the Constitutional Convention entrusted with writing the 1845 Constitution for Texas a trust for the protection of the posterity of Texians, of which I am one. These 60 men scribed a trust indenture with the Constitution's Article 7, subsection 20, Article 13, subsection 1, 2, 3, and 10, with the purpose and intent to protect the rights of men and property expressed in written form to govern the trust to protect Texians after annexation by the United States of America as successor government to that of the independent nation of the Republic of Texas, signed by all 60 men making up the Constitutional Convention. Maximum equity imputes an intent to fulfill an obligation. Trust indenture found in 1845 Texas Constitution, Law of the Trust. Does anybody else want to read, or I can continue reading? Or continue. 1845, Texas Constitution is in full force and effect unless repealed or expelled or expired. Let's see. Section 20. Was Article 7, Section 2, Section 4, joining the U.S. as a state. Section 20, the rights of property and of action which have been acquired under the Constitution and laws of the Republic of Texas shall not be devastated, nor shall any rights or action which have been divested, barred, or declared null and void by the Constitution and laws of the Republic of Texas be reinvested, revived, or reinstated by this Constitution. But the same shall remain precisely in the situation in which they were before the adoption of this Constitution. Moves to subsection 18 of 1876 Constitution, repealed November 2nd, 1999. Let's see. With temporary transition provision for Section 18, see Appendix Note. Let's see. HJR number 75, Section 901, 77th Legislature, regular session 2001. A. This section applies to the amendments of the Constitution proposed by HJR number 75, 77th Legislature, regular session 2001. B. The reenactment of any provisions of this Constitution for purpose of amendment does not revive a provision that may have been implied repealed by the adoption of a later amendment. C. The amendment of any provision of this Constitution does not affect vested rights.
All right. Even though it's talking about Texas, that's just a sample. The grants was way before 1875 of the adoption of their constitution. All right. If you look, Louisiana is right next to Texas. Portions of Texas.
Yeah, it's actually, I think Texas is probably like, we can reach Louisiana probably in like 30 minutes. 15 minutes.
Yeah. So Louisiana, portions of Texas actually belongs as part of the so-called Louisiana Purchase. So therefore, our right to portions of Texas overextends and succeeds their recognition of what he's talking about here. All right, so we go and look at our information in order to see the correlation. All right, can someone read this for me? This is the state of Louisiana.
Wood, I can't see that, Chief. A little too small.
Okay. What about now?
Yes. Let's see. Division of Administration, State Land Office. Let's see. Radiosity Gosson, Empress of the Washita, P.O. Box 1051. On January 8th, dear Ms. Gosson, on January 8th, 1992, you requested that the cancellation be issued relative to adjudication for underpaid property taxes for the year 1841 in Washita Parish, Louisiana, in the names of Daniel W. Cox, Wayne F. Harrison, G.M. Turner, C.G. I believe that's, can't make that out.
Yeah.
We have, was that Hershey?
Yeah, C.G. Hershey.
C.G. Hershey. Sue Henry Turner, Sarah Tyler, Koff Herium, and Eliza Creekman. Total of acres together being 68,883 acres. Article 10, Section 20 of the Louisiana Constitution of 1921 states, whenever any immovable property shall have been fortified or adjudicated to the state for the non-payment of taxes due prior to January 1st, 1880, and the state shall not have sold or disposed of some, nor disposed the tax debtor or his heirs, successor, or assigns. Prior to the adoption of this Constitution, it shall be conclusively presumed that such forfeiture or adjudication was irregular and null, that the property has been redeemed, and the state and the assigns, not sure, what's that say after assigns, the subjugate, or the assigns, after hereto shall forever be stopped from settling up any title to such property by virtue of such forfeiture or adjudication, provided that for a period of 3 years from the adoption of this Constitution, the state shall have the right to enforce the payment of any unpaid taxes for the non-payment of which the property was forfeited to the state. Whenever any immovable property has been forfeited for adjudication to the state for non-payment of taxes due prior to January 1st, 1880, and the state did not sell or dispose of it or dispose of the tax debtor or his heirs, successor, or assigns prior to the adoption of this Constitution of 1921, it shall be presumed conclusively that the forfeiture or adjudication was irregular and null, or that the property has been redeemed. The state and its assigned shall be stopped forever from claiming any title to the property because of such forfeiture or adjudication. This one right here, Chief. Another. Whenever any immovable property has been forfeited or adjudicated to the state for non-payment of taxes due to prior January 1st, 1880, and the state did not sell or dispose of successors or assigns prior to the adoption of the Constitution of 1921, it shall be presumed conclusively that the okay, I read that one right. My bad. These constitutional articles negate that the need for any further action that this office should take relative to your request may suggest that you seek private legal counsel relative to any actions or titles, ownerships to the affected property.
All right. So this is the heirs of Turner versus the United States. We just seen that they did win the case, but this verifies the fact that they won the case. Okay. All right, so let's read from this valid Spanish.
Valid grant that we sent to you from valid grant from the Spanish.
Mm-hmm.
Valid grant from the Spanish government to the said Marquis de Maison Rouge, and that the same is protected by the treaty made between the United States and the French Republic on the 13th day of April, 1803, as well as by the laws of nation and the Constitution and laws of the United States. Now this court, acting by virtue of the Act of Congress of 26th May 1824, entitled "An Act Enabling the Claimants to Land within the limits of the states of Missouri and territory of Arkansas, to institute proceedings to try the validity of their claims, and also to act pass claims, and also an act passed on the 17th day of June 1884, entitled "An Act to Provide for the Adjustment of the Land Claims within the states of Missouri, Arkansas, and Louisiana, and in these parts of the states of Mississippi and Alabama, through Alabama south of the 31st degree of north longitude or north latitude, and between Mississippi and Perdido rivers, that doth ordered, adjudged, and decreed, and it is hereby ordered, adjudged, and decreed that the petitioners Sarah Tuna, Eliza Turner, Henry Turner, and George W. Turner are the true and lawful owners of and have good title against the United States, the defendants in all the lands.
Hold up. What lands did they mention? Because as we've seen, it was more than just Louisiana.
Yeah, Missouri, Arkansas, Louisiana,
right,
Alabama. Yes,
so notice that these are the same names that are mentioned in the prior letter. Eliza Turner, which is Eliza Quitman, Henry Turner, George W. Turner. These are the same names. Matter of fact, to verify, let's go back. There it is right there. George Turner, Henry Turner, Sarah Turner, which her name became Taylor, Eliza Quitman, which is Eliza Turner. These are the same names, which been verified from Louisiana that they did not even own the 68,883 acres of land. Just that little bit that they was talking about. That wasn't even Missouri, Alabama, Arkansas, etc. And in the court case, it says, have a good claim against the United States. So when was this court case overturned? So we found out that land grants can't be overturned because they come straight from God. This court case can't be overturned because that means that it would be going against God. When they already verified the fact is that Sarah Turner Taylor, Henry Turner, Eliza Turner, George W. Turner are the true and lawful owners of what? Arkansas, Missouri, Louisiana, Mississippi, Alabama, etc. Why is it so hard for us to comprehend this shit?
It's not hard to comprehend. Not hard to comprehend.
Obviously,
if you can read, you know.
Obviously, it is. I don't get it. I really don't.
And this is the public court case, correct, Chief?
Yeah. This is
So I'm trying to figure out what he said he read.
This is United States versus Turner Ayers.
So I'm trying to figure out what he said he read that she lied about in the post.
That's what I'm talking about. There is no lie.
And he ain't read this one.
No, of course. He don't read, as usual. Once again, how you make up court cases, how you make up land grants, how you make up information from the state of Louisiana, how you make this shit up. This is the actual land grant. Let's see if I can make it big enough and we're gonna read something here. Okay. Now, if you can't see right here, the Providence of Louisiana to West Florida.
Hold on, I'm trying to find it right. Okay, yeah, I see it.
Yeah.
So as much as the Marquis and Mason Rouge is not pleading of the watch.
Right. Hold up. Let's read that one more time.
So as much as Marquis de Maison Rouge is not completing establishment of the Washita with, I believe, the authorized, which he was authorized to take for the new order of July 14, 1795, and remove for the future all doubt reason of the families. It's a little hard to break.
You're going in and out, God, but that's good because it tells you 30 families. All right. Washita. These 30 families from Washita.
Yeah.
The establishment of the Washita. So she made up the name Washita. Is that what they're saying? When it's right here in the land grant. Can't make that up, can you?
Can't make that up, brother.
No.
Cannot make that up.
A little too heavy for some people to kind of take on.
Right.
They're trying to say Abu Bakari. They don't have no proof that Abu Bakari ever existed. Abu Bakari II, you know. That was two clouds I was talking about you yesterday, there, Alim. The Afro-Indigenous, whatever they call themselves.
That's fine. We used that before. But let's look here. Okay. All right, Carlos or Charles Trudeau, Surveyor General, certified and have measured in favor of the Marquis of Maison Rouge the several tracts of land represented in those parts of the plat shaded with vermilion, which may contain 30 superficial leagues, to wit, the tract number 1 on the right bank of Washita River, to be taken 5 arpents below the mouth of the bayou de la Chimere or Chaudière, and that they're descended into the bayou Calomel with the corresponding depths to complete 140,000 superficial arpents. The tract number 2 on the left bank of the river commence 2 leagues below Port Miro. And the point where lane and extend okay. And extend 1 league below the Prairie de Lee, with a corresponding depth to complete 70,000 superficial arpents. The track mark number 3 to be taken in trunk of the Bayou Lutry, and thence on a line south 75 degrees east of the Bayou de l'Air, which line to the Bayou de l'Air and the Bayou Belemi and the river Washita are to be included in the track number 3. Track number 4 on the right bank of the Washita River to be taken in front of the entrance of the Bayou Barthélemy, thus, or thence, depending on the river of the Bayou in Lutry, with such depth as that of the, some stuff can't be read. Number 3, and shall include in a quantity of 8,344 superficial arpents, which add to the first track intakes a total superficial of 208,344 superficial arpents, equal to the above said 30 leagues at the rate of 2,500 and I don't know what that is. Towards for the land, for the side of the league, the land. Sure, in this providence, being well understood that the land which may be included in the above, either by tile in form or first degrees of concession, are not to be counted in computing the preceding 30 leagues. On the contrary, the Marquis de Maison Rouge promises to be of no detrimental to the settlers occupying previously any part of the land, but remain and support them in their rights, in consideration that if they said 30 leagues shall suffer any dimensioning on any count of the previous occupation or occupants, the Maison de Maison Rouge has the right, and there would be no objection to his supplying the deficit or deficiency in any other part where the land is vacant, and that in may appear. I give this by order of the Governor General, bearing the corridorlet, all which I certify. All right. And that was Carlos Trudeau, New Orleans, June 14th, 1797. The foregoing is the substance of verbal certificate of the Surveyor General, subjoined in the plat, in which that there is other sides of the copy, filing the claim of Louis Boligny holding under Maison Rouge. Okay. All right. Can someone read that last paragraph?
We certify that the two foregoing copies are comfortably to the originals which remain in the archives of the Ministry of the Royal Dominions under our charge, and that the contractor, the Marquis de Maison Rouge, complied punctually with the terms which he purported in the said contract, and that this may be made manifest comfortably to the order above inserted of the Intendancy General. We give the present in New Orleans, the 5th of August, Gilbert Leonardo Manuel Amorzes.
Now that's interesting because it's supposed to be in 1803 when they supposedly sold the Louisiana Purchase. If y'all did your homework on that. All right. 30. It says 30/leagues. I don't know what the other word is right there. Square leagues. 30 Square Leagues by the Marquise Maison Rouge, who was at the time Louis Bouligny. Okay, somebody read this last paragraph for me.
The undersigned have observed a remark in the 25th page of the introductory part of the book entitled Land Laws that no patent has issued on the claim under consideration. With great deference for that authority, the undersigned commissioners cannot but be of opinion that the instrument date of the 20th of June 1727 is a patent, or what was usually in Louisiana denominated a title in form. Transferring to the Marquise de Maison Rouge the title in as full and ample and manner as lands were usually granted by the Spanish government, subject, however, to the conditions stipulated in his contract with the government. The plat of survey above referred to will be found subjoined to this report.
All right. So the 30 Square Leagues was subjoined to the report. To this land grant. So, join to that land grant, the 30 Square Leagues. Somebody look up what is a league of land, and it's 30 Square Leagues.
You said leagues?
Yeah, leagues of land. Land leagues, however you want to say it. Like the Justice League. League.
I believe a league is a mile, not looking at that.
All right, I got it.
Okay, what you got?
A lead of land referred to a promiscuous point of land that extends out into a body of water. Especially acting as a visible landmark or guiding point for navigation. Particularly in a coastal area, it is a piece of land that is noticeable, jugged out, and can be used as a reference point for direction. Key points about a lead of land. Navigator used a sailor often used the leads of land to determine their position or course, especially when approaching a coastline. A distinctive feature, a lead of land is usually a recognizable feature on the shoreline, like a headland, cap, or post. geographical context, the term is primarily used in military context where navigating coastal water is important. You can hear me?
Yeah.
All right. That was it for the lead I learned.
Okay. All right. So we know that the lead of land goes to waterline.
Okay.
Hey, Dr. Alim, I got a question. Since I read that, ain't that's what the Moors were doing with the European when we used to control the coastal water and shit?
Yeah.
Like when we used to tax them and stuff like that and make them pay.
Right. Exactly. Right. You get the book by David McRitchie, Volume 1, Volume 2, Ancient and Moderate Britons. He speaks about how they paid us tribute just to sail the ocean seas.
Yeah, my bad. But Brother Fahim was reading that on your podcast, on your you know what I'm talking about, the podcast thing that you got.
Mm-hmm. Yep. All right. So the Empress did not make this up. Most individuals do not have enough information, so they just talking out the side of their neck, as they say. We read the information for ourselves. If you want to read more, you can purchase a book, Return of the Ancient Ones. If you want to read more, you can also purchase my book, The First World Order.
Ain't a lot of the information already in your book?
Yes.
All right.
Yes, we can find a lot of that information in Dr. Alim's First World Order, brother.
This woman did not have to lie. She didn't. Simple. You can't fake being the mayor of two cities. You can't fake 40 years of research. You can't fake a land grant. You can't fake court cases. You can't fake replies from the state of Louisiana.
All that is unfakeable.
Right. But what we can say is that the Temple Moors, their fate, their succession line, that's what we can say. The Moor Science Temple of Ink, or Jones Bay, I believe that's his name, coming from Kirkman Bay, fake lineage. That's what we can say. The only one in which that Prophet Noble Drew Ali commended and promoted to the level of Sheik, Grand Sheik, was Emilio.
Prince, I got a question about that.
Yes.
Why do you think the prophet left the two temples with the name as Moorish Holy Temple of Science of the World and changed the rest? Do you think that was done by accident or on purpose? I was building with a guy from the
No,
5%, and he thought that he said he it was an accident.
no,
What do you think?
that was no accident. You forgot where his temples were?
What was that, Chief?
I said he forgot where his temples were?
Right, that's what I said too. So I'm like,
No, that was no accident.
do you feel like?
It was
Sorry,
civic and religious, which becomes what is known as the Moorish divine religion and national civic movement.
So would you say that the Moorish Holy Temples was left to be that civic, and while the rest is left to move as a religious?
Of course, yes.
The
Moorish Holy Temple of Science of the World is the civic side. Mm-hmm. That's why we utilize the Moorish Holy Temple of Science of the World. It's for the civic, not the religious side, which is still debating about who's the rightful successor, when none of them are. I'm more of a successor. I'm related to him.
big facts. I see. Yeah, I've been doing some deep research into the temple and how things split, especially with the Claude Green movement, moving into the Kirkman Bay movement.
Right.
They tried to assassinate. A lot of people don't even. I don't know if a lot of people really know the true history and understand that. Like it was basically like a war going on. They tried to assassinate the prophet plenty of times, and they did. They successfully did, according to the news articles. You know.
I taught it on here.
Right. Yeah. So a lot of people don't really know that history. Like there was even some people calling Claude Green a prophet at the time.
Yeah. They went along with him. He ends up getting stabbed and shot in the back of Unity Hall. Howard Johnson Bay didn't play. He's the one who shot him.
Where? It's fine.
You see? It's real simple. Charles Kirkman Bay was never made a sheik. He was an adept. So that is the criteria right there. John Givenil never made a sheik. And the lineage right there. Only one out of the three that was actually made a sheik was Emilio. Who was also an adept. But I'm going to say Ehate Washtaish.
Ehate Washtaish Nasawali.
Oh,
Yeah,
Dr.
I'll take
Alim, I got a
Washtaish.
question.
Mm-hmm.
Thanks for this
Go ahead,
class.
say what?
Dope class.
Thanks, God.
I never did my nationality, but I paid for it. I was wondering, like, how would it come? Like, is it gonna come in an envelope or
Yes, it's going to come
email?
out. What is your name?
I said, what's my name?
Yes.
Joe Gibson.
Okay. Okay.
And a lot of the information about Louisiana, I never knew. I mean, I'm from here, but I just never knew that. So, thank you for
Right.
that.
Oh, you're welcome.
So, what's the tell you though?
Ehate Washtaish.
Dr. Alim.
Yeah, they guys.
Mm-hmm.
What time tomorrow can I give you a call? This is Brother Talib from Michigan.
It'll probably be in the afternoon because I got a lot of stuff to do in the morning.
Okay, yeah, I'm on Eastern time too, so
Okay.
yeah, I'll give you a call tomorrow. I got some questions.
Okay.
I'll get a donation too.
Appreciate that.
No problem. Watch Thais.
Ehate Washtaish.